Welcome, everyone. Welcome to our program. My name is Rebecca Fike, and I'm a partner in our shareholder litigation and enforcement, government investigations, and white-collar defense practice groups. So this is the first and what I hope will be an ongoing series called Navigating Inside the SEC. I joined B&E almost exactly a year ago after 10 years at the commission in the Division of Enforcement. So I've done one presentation on kind of looking inside the SEC and how it works. And what I'm hoping now is on an ongoing every 6-month basis doing an SEC update where we look back at the previous 6 months of actions, commissioner public statements, rulemaking, speeches, and anything else public to kind of reflect on what has the SEC done recently, and then more importantly, what might that mean for the future? What are the takeaways that companies and executives, attorneys, accountants should be taking from that? And my goal is really there certainly will be some, top headline cases that I look at, but I think there are some cases that get a lot of attention. I'm sure everyone in this room and online has been to an ESG related presentation in the last year. And my goal is more to pick out some of the cases and statements that maybe didn't hit the headline news in the same way, or that perhaps you have not already attended a full hour-long CLE on that topic. So ESG will come up, but it's going to be a very small part of this presentation. And additionally, if there's anything that any of our listeners would find particularly helpful to hear about in the future, definitely let me know. This is an iterative process, and kind of every 6 months we plan to make these. So if there's a certain area that is particularly complex or particularly applicable to your job or your industry, happy to keep an eye and ear out for that and include it. So on that note, today we're going to jump around to a couple different topics. We're going to talk about shifts in enforcement priorities as we've kind of gleaned them from their public actions. We're going to talk a little bit about certain new rules. There's been an enormous amount of rulemaking this year, and I'm sure you've heard of a lot of them. So we're going to focus on maybe some that didn't have as much attention, and then we'll also look at some of the SEC updates that are actually outside the SEC. For example, what the Fifth Circuit has ruled on with regard to SEC administrative law judges. Look a little bit at the PCAOB budget and how that might affect you or your auditors. And then obviously leave time for questions at the end. Overall, as you've probably seen, 2022 was a banner year for the SEC, particularly the Division of Enforcement. While their numbers were pretty static and flat in fiscal year 2021, there was a 9% increase in the number of actions this year as opposed to last year. And really, even behind that number, it's even greater because it's not just a 9% increase in the actions, but it's an enormous increase in the amount of remedies sought, in the size and breadth of some of those actions, in the remedies, civil penalties, disgorgements when sought. Overall, it really is bigger than that 9% figure shows. There was $6.43 billion in monetary relief sought by the SEC in 2022. Civil penalties made up $4.19 billion of that number, which is a 3x increase from the year before. So civil penalties have really become a way that the commission is talking to the market, to companies, and to individuals, whereas disgorgement, which is directly correlated to the unjust enrichment, that amount has actually gone down. But civil penalties have gone significantly up. The SEC appears to really be focusing in their speeches and their actions on the messaging to the public. There's been a lot of talk about the civil penalties and how the goal is to disincentivize future bad behavior through civil penalties, where disgorgement is used to, right a wrong or to try to make whole harmed investors. The civil penalty has a lot more leeway, can be a lot higher, and really does vary under different administrations, different enforcement directors, and others. So you can glean a lot from what cases and attorneys are doing on the penalty side. There's also been a lot of talk in settlements, so in settled orders where there's a penalty. In the past, and really the whole time while I was at the commission, you would settle on a penalty number based on usually some kind of a spectrum of past cases. There's this case with this penalty, this case with this penalty. Our behavior is in the middle based on monetary, people involved, time period. So our penalty should be here. That analysis is really no longer how staff is looking at settlement penalties. Now it's past case here, past case here. These weren't sufficient to deter the bad behavior, so the penalty should be here. Not saying that's always correct, and we have ways to talk about that and negotiate that and massage that point. But the previous idea that pointing out a higher penalty and saying we should be less than that is really no longer the best negotiating tactic. Now you're better off really focusing on what makes your case unique, what makes your facts unique, what makes your company one that has, let's say there was, wrongdoing that's been addressed. How have you handled it and ensured this will not happen again? How did your robust policies and procedures catch this wrongdoing? I mean, there's a human element to everything that we do. Sometimes people are going to mess up, whether on purpose or on accident. That's okay. How can you show that the procedures you set up caught it? How can you show that the values the company has, punish the wrongdoer or made changes to make compliance even stronger, and really talk up your unique story as opposed to doing a lot of the comparisons we used to do to past cases. There's also been a much bigger focus on issuers, audits, and accounting, whereas there were fewer cases in 2022 on kind of your bread and butter securities offering frauds. So the kind of classic, fraudster offering securities in something that doesn't exist. Yes, they still do that. Yes, that's still important. But in the last year, there's really been a focus on looking at larger industry participants and entities and individuals that touch on so much more of the market as opposed to, for example, like a private offering fraud. And then on the ESG, they've really been a focus on the G, on the governance aspect of that. I mean, in part because the ESG rules aren't final yet, so we'll see what happens with those. But there have been quite a few cases kind of on that G factor, and we're going to talk about that. All right, so our shifts, kind of pulling out more shifts in enforcement priorities, a focus on disclosures. So this is a case that actually just came out in early January, about two weeks ago. The CEO of McDonald's had an inappropriate relationship with an employee. McDonald's terminated him without cause, which allowed him to retain about $44 million in equity compensation. So a significant amount of money. It was later discovered that the former CEO withheld information during the internal investigation about other potentially inappropriate relationships that he had with employees. And there was an SEC investigation along with that, where the former CEO was found to have violated the anti-fraud provisions, as well as causing a violation of Section 13A, which is a misleading or materially false information in a periodic report, because McDonald's had filed an 8K surrounding his exit from the company, describing this one inappropriate relationship he had. Turns out it was allegedly quite a few more than one. Interestingly, though, the commission found that McDonald's violated Section 14A of the Exchange Act and Rule 14A3, which relate to the proxy statements, for violating item 402 of Reg SK, which requires companies to explain all material elements of the compensation of the named executive in the proxy statement. Here, according to the SEC, McDonald's had failed to note they exercised discretion in terminating him without cause and allowing him to retain that $44 million in equity-based compensation. Because the company could have not done that, per the SEC under item 402, they were required to tell shareholders that when they were voting to approve that executive compensation, that they needed to tell that whole story. It is the first time the SEC has applied item 402 to require disclosure of a company's discretionary decisions regarding the characterization of an employee's termination. Importantly, there was a dissenting opinion publicly filed by two of the commissioners, Commissioner Peirce and Uyeda, saying that they felt it could create a slippery slope that might expand item 402's disclosure requirements into unintended areas, and that it was regulatory expansion through enforcement. But it wasn't an approved action. It is now a commission, settled order. And it's a genuinely interesting case. And I think it actually speaks to a lot of what the commission has done in the last year which seems to aim at the idea of wanting companies in their disclosures to take a step back and look at their disclosures as a three-dimensional picture they are painting of whatever it is they're asking shareholders to approve, or what they're saying about, risks, or what they're saying about financials in the year ahead, and thinking about, if this is all you knew about the company, is this a fully accurate picture? It's not that what you wrote is wrong, it's that per this case and others, there's not certain information that they consider material that would have painted a potentially different picture. Yeah.
When they filed the 8K, did they know about the relationship?
No. And that's why the CEO was charged with that causing violation, saying you caused McDonald's to file that false statement. McDonald's itself did not get charged with the Section 13A. And so here, I have teenagers, so we communicate through GIFs and memes, trying to sprinkle some throughout our conversation. But as I was just saying, it really seems like this is what the commission's message is. And, whether we agree with every case that comes out showing that, that is a common theme throughout many different industries, cases, actions, this idea that you were not painting a fully accurate three-dimensional picture of the situation, the compensation, something you're asking shareholders to approve, something about your financials that someone might use in their investment decisions. Like, are you telling the full story? Another kind of recent focus, very large focus of the SEC has been in the ephemeral messaging area. Again, I have teenagers, so I know more about ephemeral messaging apps than I maybe wish I did. But there are many apps out there where you communicate and the message disappears. It's set on an auto delete cycle. It's never saved. There's, aspects to the app that make that true. The problem here for companies is that oftentimes employees use those apps to communicate about company issues, company topics. Customers, clients, financials, that's just how they communicate. This is especially true often in offices outside of the United States, where WhatsApp is just, a way of communicating. And WhatsApp does not automatically retain your historical text and information. So this is an area where they're kind of putting this under that G in ESG and looking at the governance and making this statement that record keeping is absolutely crucial to the ability for them to enforce the federal securities laws. There were several cases on this point. The first one was the JP Morgan Chase case, where JP Morgan agreed to $125 million civil penalty for not preserving and maintaining the past communications with employees on these ephemeral apps. What's fascinating to me about this is that even in the order, it doesn't say that there were certain messages missing that got in the way of the SEC's investigation. So they aren't pointing to a hole saying, we could have brought a case, but we couldn't because you did not retain these messages. Rather, the order said that the fact that the banks did not retain and preserve these messages likely impacted the commission's ability to carry out its regulatory functions and investigate violations of the federal securities laws. They were basically able to draw a line between, you are not preserving and maintaining these, we sent you subpoenas in this time period that called for communications. Therefore, you must not have had some that would have been required under that subpoena. It likely impacted our ability, and it's a $125 million penalty and an SEC action. The SEC then also announced there was a joint settlement with, I believe it was 16 different investment advisors and banks, with penalties that added up to $1.16 billion for the same violations. The CFTC joined that same action, and there were additional penalties levied by the CFTC that brought that total up to $1.8 billion. So it is a sizable material amount of money, and it's a genuinely challenging issue. The SEC points out the problem, but it's hard to find the solution. And part of what impacted in that case was there wasn't, per all the public documents around it, any evidence that the banks were trying, that they had considered this issue and had a policy in place. Maybe some of them had like a one line of, you must use the company's official email to discuss bank business. And the SEC is saying that is not enough. You need to acknowledge the fact these apps exist. You need to have a policy about them, and you need to make some effort to enforce that policy. And then recently, and this is just what I've heard from others kind of in the defense bar, and there's actually an assistant director at an FCPA conference yesterday who spoke to this, who's currently at the SEC, saying that one of her first questions now in an investigation is, no matter the subject of the investigation, what is your ephemeral messaging policy? How and when do you test it to ensure people are complying with it? And what are the results of those tests? That is now just kind of a standard ask in investigations right now, because what the SEC is doing is saying, we put out these huge cases, millions and actually billions of dollars in penalties. Are you paying attention, and what have you done? And there's a lot of nuance there we would have to get into in a more private session, but they really are looking to see, are you doing something about this? And a one-line employees shouldn't do that is not going to be enough. And then we're all still figuring out what is going to be enough. Yeah. No.
I remember being stunned when I saw those fines. And part of it was because, like, for us, we will communicate with our clients in whatever way is convenient to them. So the GC sends us a text or a WhatsApp, it's unlikely that we're going to say, sorry, I can't communicate with you this way. So that's kind of a practical thing. But was there a predicate? I mean, did the banks know that they were going to get popped? I mean, that seemed like massive fines unless there was a predicate.
No, and that there was not really a clear predicate. They wouldn't have been surprised by the amount just because that was a negotiated settlement. It wasn't a litigated. Oh, I'm sorry. Great point. We have a question on, were the banks surprised by such large fines, given that just by practical nature, you communicate often with clients or stakeholders in whatever way is convenient to that person, and you're not kicking them off that line to go do something else. And I would say there was not honestly a clear predicate, but they were negotiated settlements. So they did get there, and they weren't surprised when the press release came out. Now, they probably were surprised as settlement negotiations began as to what numbers this commission was starting at. It was a huge action that sent waves certainly through the industry, and it's one of the challenges of making statements that way, because all we have to go by for guidance is what was not enough or what was insufficient. We don't yet have much, if any, color on what would be, because there are practical considerations there. And, maybe it's that you start your communication that way, but then it's incumbent upon you to preserve those. So make sure your phone doesn't delete them, or make sure, there's a lot of ways you can get at it, but agree completely. You have brokers. I mean, I've talked to attorneys who tell me they talk to their brokers via text message all the time. And, that actually doesn't comply with the record keeping requirements of a broker dealer. So, we have attorneys aiding and abetting and breaking that rule, but it is a tricky issue, and we're working on good solutions. And I think right now, one of the biggest answers is acknowledging that it is challenging and tricky, and trying to figure out something that responds to it, as opposed to just kind of, well, we have official email and that's what they're supposed to use. I think that clearly is not going to be enough. Okay. Another issue that came up a lot in the last year are statements on social media, and I would expand that to really anywhere outside of public filings. I don't know if this is as true anymore, but when I was doing a lot of investigations, as social media kind of became a way that now even, very blue chip companies, executives were using to communicate with investors, there was kind of a genuine disconnect between the idea that what we put in our 10Qs and 10Ks and even our 8Ks, we scrub that, we are so certain, we have backup for all of it. But when your CEO goes and does a podcast, or posts things on Instagram about the company or Twitter, that usually funnels through the marketing department. Legal often doesn't see any of that. There's no backup for it. I had cases where no one had ever listened to it, and I played it for the GC, and he was very surprised by what the CEO had said on a podcast. But that's where retail investors are listening to companies. I would imagine your average retail investor is not reading the K necessarily, not to say those aren't important, but they are following the company on Twitter. They're following it on Instagram. They're listening to podcasts where the CEO is talking about the company. And those statements are public statements. They're public statements to the same weight and effect as something the company writes in a filing. And that is something if it is not already part of your company's review process or approval process, it absolutely should be. And it goes beyond just the company's official social media channel and expands to, for example, a CEO. I don't think, your average like hourly employee is speaking for the company, but when you have a pretty high up executive where their Twitter handle includes the company name or includes their title, and they're talking about, projections, financials, deals, products, this is someone who I think an investor could reasonably think is speaking for the company and that they could rely on what this person is saying. And you need to make sure that those statements are accurate. There's also a lot of instances where we saw that marketing department reviewed those and made sure they were consistent, but no one was going back and checking with the engineering or the science or the finance folks to make sure it was true. So you had consistently inaccurate statements that marketing was giving a check mark to because it all matched. They didn't know what the science was, but no one was actually looking at, what is the truth? And then in one particular case that I did, you had text messages between the engineers talking about like how much the CEO was lying, because none of that was true. And in that case, the messages were actually retained and we did get to see them. But you do have to be careful there. And there have been some big cases on that. The Trevor Milton Nikola case, there's a $125 million penalty to the company because of false statements the CEO made over social media. Kind of an interesting one, there's another case, SEC versus Andrew Vasari, where this was a social media case where the person doing the speaking had no affiliation with the company at all, and the company was not charged, but this individual had bought stock, gone on Twitter, and talked up the company and how great it was and these deals it was about to do, all of which they made up completely. And they developed this following on Twitter about them being someone who talks about the market and knows what's going to happen. None of that was true. His stock price went way up. He sold it, made a whole bunch of money, and had no affiliation with the company at all, but that's still stock manipulation, and he was sued for securities fraud. And then there's the MoviePass case where there were misleading statements on online media and podcasts, where even if your financials are accurate, the statements that people are listening to were not. And I should note in the Nikola case, Trevor Milton was found guilty. He was criminally convicted by a jury, and the SEC civil case is pending. It was actually the last case I worked on when I was at the SEC. All right, okay. We have some questions. Okay, we'll get back to those. All right, SOX 304 clawbacks. This is another big area, maybe not as fun and sexy as some of the others, but it is an interesting and pretty significant shift and change. So SOX 304 says that the SEC may disgorge any bonus or incentive-based or equity-based compensation or profits realized from the sale of securities of a company from the CEO and CFO when the company is required to prepare an accounting restatement due to its material non-compliance as a result of misconduct with any financial reporting requirement. It's long and wordy, relies on material non-compliance as a result of misconduct, which is not defined, only applies to the CEO and CFO, but applies to a pretty broad array of equity-based or incentive-based compensation. The clawbacks are not meant to be punitive per kind of comments on the rule. The idea is they are necessary to ensure that companies and shareholders are not harmed by fraud that occurs at the company. It is not disgorgement, so it's not limited by the amount that a defendant was unjustly enriched. It's supposed to be an incentive for companies, for CEO and CFO to put in and support robust compliance and internal controls over financial reporting. Importantly, the money that is clawed back through a SOX 304 clawback goes back to the company. It is not a civil penalty that is paid to the SEC. It's money that goes back to the company. And again, the idea being if wrongdoing caused a restatement which harmed the company and shareholders, an executive who received incentive-based or equity-based compensation in that time, that money should go back to the company. This remedy has been available since 2002. It was used for the first time in 2007. It was used more under Chair Mary Jo White, whereas under Chairman Clayton, it was used much less. But historically, it's been kind of a lever the SEC can press, but they haven't always. It's depended on, administration priorities, focus, maybe cooperation of a company or an individual, but it was by no means automatic that in every case you would see a SOX 304 clawback where there was material noncompliance as a result of misconduct. That appears to be changing a bit. Now that is very much the expectation that anytime there's a restatement, there will be a SOX 304 clawback. And in fact, it appears that the SEC will not really consider a company to have cooperated in the investigation unless they have tried to claw back executive compensation during that restatement period. That's considered part of cooperation is following SOX 304. They've had 3 cases just this past summer in 2022 that really highlight the fact that while the facts can be different and additional remedies can be different, the SOX 304 clawback is the same. There was one in United Health where the CEO actually caused the fraud, deliberately, intentionally caused the fraud that led to the misstatement. And there, SOX 304 applied to any and all covered compensation. And that CEO was also charged with additional, anti-fraud violations. So that one makes sense. In the same month, there was the Synchronos case where the CFO caused aspects of the fraud that caused the restatement. The CEO, by all accounts from the SEC's and the company's own investigation, did not participate in the fraud, did not know of the fraud, and when he learned of the fraud, fired those who were. So acted as you would want your CEO to act. That said, while the CFO certainly faced additional charges, and I think there's still a litigated action against him, whereas the CEO did not have any charges filed against him, the SOX 304 clawbacks applied the same. So both the CEO and the CFO had to return any and all equity and incentive-based compensation for the time period of the restatement. So that's where there's still a difference. It's still worse if you're the one who caused the fraud. But as far as SOX 304 goes, the SEC has been fairly blind to that. And then there was one more in August. It was a Granite Construction Co., where again here, it was a senior vice president who caused the accounting fraud within his group that was material to the company's financials and caused them to be restated. The CEO and CFO were found to be unknowing of the fraud and cleared of any misconduct. Their comp was also clawed back for that time period. And so I would expect to see that continue. And this one we won't spend a lot of time on, but I think it's one of the aspects kind of the ESG world that hasn't gotten quite as much attention, but it's the proposed changes to the names rule. So Rule 35D1 of the Investment Company Act of 1940 there have been past rules that have meant, that you can't use certain names, like you can't say it's like the SEC approved fund, or, you have to have kind of a truth in marketing to your fund names. But they are now looking at proposed rules that substantially expand what funds the rule would apply to, and it would require funds to amend their prospectus disclosures with more details that support the fund's name. So, for example, if you have terms like growth or value, or something about that you're looking at, social factors or environmental factors, or that the fund is named after some value that you think investors like, you now need to show that there's an 80% investment policy requirement to those names. So you actually have to look at the makeup of the fund and ensure that that name is 80% accurate to the fund. And that comment process is actually still open. So they've sought comment specifically on certain aspects of that rule and whether, integration funds, how that name rule should be applied and other things. But it was one where that rule was open. It opened, I think, initially in March 2020 for comment. It kind of got ignored, and then now it's back being reopened and now actually has a close date for the comment. So I would expect those rules later this year. We get to get back to clawbacks. So this is slightly separate from the SOX 304 clawbacks. The main takeaway being really look at executive compensation policies. If you're a board or if you interact with your board, you're going to want to look at what are your tools for executive clawbacks. How would you enact that? How would you look at that? If you have foreign offices or executives, if you're a foreign private issuer, you have to start thinking about, do we have the mechanisms in place to claw back compensation if that was necessary? That's something that there will be questions about that in that situation. But here we're looking at Section 10D1 of the Exchange Act, which has mandatory clawbacks that are triggered only when there's an erroneous award of compensation results from the company's material non-compliance with financial reporting rules. So there has been the new rule, the final clawback rule, has substantially expanded what this rule was previously seen to do with executive clawbacks. The word material is very broadly defined. Previously, it was seen that an issuer had a duty to do a mandatory clawback when there was what they call a big R restatement, a material restatement that affects historical financials and requires a full restatement of previously issued financials. That was seen as triggering the clawback rule. Now, per the final rules, a little R restatement could do the same. Materiality is now, it doesn't honestly have the meaning material. It means anything could be material because maybe over the years it's material, or maybe in light of qualitative factors it's material. But the concern in the industry is that now little R restatements, which are they're immaterial adjustments made in normal course, that is now covered by the restatement rule. It's also significantly broader in that it applies to any officer in a policy-making function. So any officer with the power to affect what your reporting rules are or other things would be captured in that. It is not just the CEO and CFO like the SOX 304 rule. It applies to foreign private issuers, emerging growth companies, smaller reporting companies, controlled companies, and all issuers of debt and other non-equity securities. Importantly, as part of the rule, a company cannot indemnify or insure its executives against recovery of the clawbacks. And the interplay with SOX 304 is that compliance with SOX 304 would be credited towards the amount recovered under Rule 10D1. However, recovery under 10D1, this one, doesn't preclude additional recovery under SOX 304 to the extent that is a larger number. So if the time period that would be covered under the SOX 304 rule is broader and it implicates more money, complying with Section 10D1 doesn't get you off the hook for the rest of it. And on a kind of criminal side, the DOJ, the Deputy Attorney General Lisa Monaco, has made public statements that in internal investigations, in criminal investigations for corporate misconduct, where a company has voluntarily exercised deterrence mechanisms for employee misconduct, which includes clawing back compensation, that will be very favorably considered in any resolution with a corporate entity. So that's not the same rule because they're not, the SEC has the securities rules, but they are saying that will play a role. Shadow trading. So I'm violating my own premise a little bit because this was more than six months ago, but I think it's an interesting case and one people should be thinking about. So the Panawatt case is one where Panawatt, who was a pharmaceutical executive at a company called Medivation Inc., he, in his capacity of whatever he was doing at that company, learned that Medivation was going to be acquired by Pfizer. He used that information and went and bought stock in another company, Incyte, that's in the same general kind of market bubble as Medivation, under the theory that, well, if we're about to be acquired by Pfizer, there are now fewer acquisition targets out there for a Pfizer, and their stock may go up because the price of them may go up. So sound economic theory, it worked, the price did go up, and then he sold, but he was charged by the SEC for insider trading. And he's not trading in his own stock, and he's not trading in the stock of the company that acquired his company, but he used information he received as an insider in order to purchase securities in another publicly traded company. Now, this case has still not been resolved. They're in the discovery phase. It is a litigated action. He did not settle. But what's been interesting is so far it has survived a motion to dismiss, and the court, in their ruling on the motion to dismiss by Panawatt, used the language from Medivation, his company's insider trading policy, in order to deny the motion to dismiss, because the company's insider trading policy prohibited the use of non-public information to trade in the securities of, quote, another publicly traded company. And I can tell you, having now looked at many companies' insider trading policies, because a lot of them get sent to me to look at, every company policy I've looked at says the same. And so while this case has not been resolved, we don't have a ruling yet. We don't know if on the merits the court is going to support this, kind of shadow trading theory. It's certainly worth taking a look at any company's insider trading policy and thinking about, do we really want to say that? Do we mean that? And if we do, are we policing that and enforcing this policy to that meaning? Or are we only looking at, our employees trading in, our securities or securities of, a company we have relationships with? Because if that's going to be in your policy, then that needs to be something you have policies and procedures in place to enforce. So sort of that check of, did we mean that when we said that? And so there's not necessarily a right or wrong answer, but it's worth looking at and making sure that is the intent that you meant to have. And, do you want a Panawatt case where you could have an employee being charged by the SEC for purchasing securities in the same market as your own company, but not your company? So we're all waiting to hear more on that one. All right, so on SEC updates outside the SEC, there was an interesting Fifth Circuit case, which is the federal circuit court that would cover Texas federal civil or district court decisions. It's an old case actually from the SEC. It started many, many years ago. It's one of those that through different procedural things and appeals and all of that just keeps on going. But it's against a man named George Jarkisi and Patriot 28 LLC for securities fraud. It was done through the Administrative Law Forum that the SEC was given jurisdiction over fraud cases under the Dodd-Frank Act. And when it first came out, the SEC did use the ALJ, the Administrative Proceeding Forum, for substantive fraud actions. They really don't now. They use it more for like follow-on orders or revocation of registration, or not where you're like truly finding the guilt or innocence of someone on a fraud charge. But back when this first started, they did, and they were authorized to under Dodd-Frank. And so here, the defendants have appealed in part based on saying that it was that using an administrative law court for this type of decision was unconstitutional. They failed at certain levels to convince a court of that, but this past summer, the Fifth Circuit vacated and remanded the prior court's decisions. What was interesting is they could have vacated and remanded based on any one of the reasons they ended up writing that they did, but they made sure to go as far as to write out all these additional ways they felt that the decision needed to be vacated, and they're pretty far-reaching. They said that petitioners were deprived of their Seventh Amendment right to a jury trial, which could be applied to all kinds of different administrative type actions and administrative courts that happen in all sorts of different regulatory regimes. That Congress failed to provide an intelligible principle to guide the SEC in selecting a forum for certain actions, which violates the non-delegation doctrine. And they said that the 2 layers of for-cause removal protection for administrative law judges violates the take care clause of Article 2 of the Constitution. So they found many ways to point out that they do not like these administrative proceedings and administrative law judges. That case has been remanded. The Fifth Circuit declined to rehear the case en banc, so that decision stands. There was a deadline to apply for cert to the Supreme Court of January 6th. That was just extended to February 17th of this year. So we'll see if they petition for cert and if it's granted. So far, the issue has come up in one other circuit court in the Sixth Circuit, and they decline to follow the Jarkisi example. So we may end up with a circuit split on administrative law judges, but it's an interesting issue because it does a little bit affect kind of your strategy in working with the commission in the forum that you select. And there's certain remedies the SEC has that can only be brought in an administrative forum. So does Jarkisi apply to those? Does it apply if you're only in the Fifth Circuit? So if you happen to be in Texas and then you happen to have a revocation of registration done in an administrative law proceeding, have you only been denied your constitutional rights, but someone somewhere else hasn't? There's not answers yet, but it's just an interesting point that those in this area of law are following closely. And then this last one is just because I wanted to pull out an area that I don't think gets a lot of attention, that there are certain regulatory bodies that the SEC itself regulates. And in fact, the SEC, for example, here with the PCAOB, the SEC approves the PCAOB's budget. So it's kind of a regulator within a regulator. There's often not as much maybe visibility into that world. And here, and the reason this even got really any attention is because Commissioner Peirce filed a dissenting opinion or statement about the PCAOB's ballooning budget that she didn't feel was justified or should be approved, which kind of pulled some attention to it. But the PCAOB is, I'm going to get it wrong if I say it, but it's the Public Company Accountability and Oversight Board, I believe. It oversees the audits of public companies and SEC registered broker dealers. So their main kind of functions are registering public accounting firms, inspecting registered firms, establishing auditing standards for public companies, and then conducting investigations and disciplinary proceedings of those firms. So it's sort of a public company accounting firm sub of the SEC. And they have their own budget, which the SEC approves. And that budget has gone up substantially in the last several years, including for its most recent budget. It was about a 10% increase in accounting support fees, which public companies must pay, and a 12.6% increase in their overall budget. And there's just kind of, it's kind of kicked off some thought pieces and other things on, what is the PCAOB's role if the SEC is now being aggressive in a lot of different areas? And also, the SEC charges accounting firms too. Kind of how is that interplay? Why do they have this other kind of larger budget and more visibility into them? The budget was approved over Commissioner Peirce's objections, so that is what it is for fiscal year 2023. But it may be interesting if there's, the SEC has to give a report to Congress every year on their results and kind of what they've done and other areas of visibility like that, if perhaps the PCAOB at some point will also. But this can affect, if you're a public company, the fees your auditor is charging. It can affect, the extent to which, they are now having to protect their own potential liability from an active enforcement regime. And all of that obviously trickles down to their own clients and customers. All right, so we have about 15 minutes and I have more I can talk about, but I wanted to pause and look at some of the questions. And obviously, if we have more in the room, please ask, including if it's nothing I touched on. Okay. Question from online. If ephemeral statements require record keeping, then what about phone calls? How are they different? That is an excellent question. So depending on what type of company you are, broker dealers do have an obligation to record phone calls. And I know this because I've had to listen to like hours of recorded phone calls when I was an enforcement attorney at the SEC. It is slightly different in that it depends on the company whether or not a phone call is considered having to make a record. It's the record keeping requirement the SEC is enforcing in those ephemeral messaging cases. And if you are simply a public company, talking to an employee, a phone call is not considered to have made a record. You haven't made a record, you had a conversation. But in, for example, an investment advisor or a broker dealer, some of those conversations where you are either giving investment advice or, deciding to enter into a transaction, by the rules that govern a broker dealer or the rules that govern an investment advisor, they have additional record keeping obligations where certain of those phone calls do trigger that record keeping requirement. And so I know, for example, certain brokers, they have phone systems that they have to use. Now, I don't know how you handle when your client texts you or uses a different format, you are supposed to tell them, let me call you back and use that system. So it is tricky, but it's not that every phone conversation is being triggered by these ephemeral messaging cases. Okay, I have a new one. Broad question, but does the SEC Enforcement Division, as of late, have certain focuses for private companies, or has there been an uptick in enforcement for certain areas for private companies? That is a great question. There seems to have been lately a real focus on public companies, on the idea that, it's their disclosures that market participants who otherwise, don't know anything about the company or wouldn't be connected to it or wouldn't know to invest in it, and ensuring that they're protected and that the full world of information for them is accurate. Whereas private companies are generally funded maybe through a PE fund, hedge fund, private investors, those who are connected to the company. So while I'm not at all saying they aren't still a priority or something of interest to the commission, I do think right now the reason we are seeing such a focus on public companies and gatekeepers like the investment firms is that it's seen that those are touching on market participants who are not, otherwise connected to the company or kind of have their own protections like a PE fund. I don't think I have honestly seen much either in the speeches or statements that the commissioners have made speaking specifically to private companies. So while, not off the hook by any means, and it's still worth looking at, ensuring anyone on behalf of the company isn't speaking falsely in investor presentations and other places. But I think public companies certainly have a longer, clearer list from the commission in the last year. Let's see. Is the enforcement focus on ephemeral messaging policies relevant only to broker dealers and investment advisors, or is it a concern for publicly traded companies? Yes, it is a concern for publicly traded companies who are not investment advisors and broker dealers for sure. One, if there's a litigation hold, are you retaining records? If your record retention policy says that you save, instant messages, do you? A WhatsApp could be considered an instant message. There are other things that might fall under that category. How are you defining what you yourself as a company say that you're retaining? So even separate from an overlay rule coming from the SEC, what are you saying you retain, and are you actually doing that? And then in addition, and this would depend on the company and the industry and all of that, and maybe potentially other regulatory bodies that govern you, there can be record requirements outside of just an investment advisor and broker dealer. If you were, and I'm trying to think of an example, a public company that doesn't fall under any other regulatory body with any other rules, I mean, you can generally have the record retention policies that you want. You just have to actually have them, actually apply them to the full category you said you apply them to, and have an ability to stop them when you do have a litigation hold or when there is an SEC, inquiry or other matter. And for some, that has also got them into trouble. It's not that they had an additional layer of requirement. It was that, there's a litigation hold that said to all communications, and they were not preserving those. Okay. Sorry, there's one more question I'm reading. If there is an investigation by the SEC, are they anticipating that issuers are patrolling and prohibiting use of ephemeral messaging due to the fact that it leads to the destruction of potential evidence? So should we consider the ephemeral messaging fines and enforcement limited kind of to the financial industry or more broadly? So that's kind of been answered. And I think, again, what they really want to see in the next year is that you're thinking about it. Depending on the staff attorney, they might have stronger opinions on how you should be thinking about it, but it's definitely a better answer to be thinking about it, to show that your board is considering it, to show that you're looking at ways to ensure you're retaining what you need to retain, as opposed to our employees use WhatsApp and that's just what they're going to do and there's nothing we can do about it. I do think it's tricky. I've talked to some, CCOs and other executives at companies that are saying, we have a policy and we're trying. We don't really want to test the policy because we are 100% certain a ton of our employees would fail it, and we don't want to have the results of that test. Like we don't want to see that because we know, for example, that our subsidiary in Brazil is absolutely, using certain text apps that are not actually officially supported by the company. And I wish I had a great answer for you. I do not, but I understand that tension. And I think part of it is going to be, as it always is, a back and forth of educating the commission on the actual practical challenges of that, showing, again, that idea that you want to be a good corporate citizen and here's how you are trying to do that. And then just having that allowance for the human factor in it. But this idea that the commission is now asking for not only your policy, but proof that you've tested it and the results of that test, I think is very tricky and, needs to be talked about further on it, individual company and market and geographic basis, because that is a very challenging issue. And it's sort of like several years ago, the KBR case had, that you couldn't impede a potential whistleblower from speaking directly to the SEC. And it was a phrase that was in their confidentiality agreement that said, you must report to the GC before you report outside of the company. Well, this violated Rule 21F17 under Dodd-Frank. That case came out, and then for a while afterward, in any investigation the SEC had, you would ask for a copy of their confidentiality policy because you wanted to see, Are they paying attention? Did they read that case? Did they take out any potential language that says, you have to get approval to report to the commission? I think that's a little bit of what's happening here now with the ephemeral messaging. It's not that everything's figured out yet. It's that you want to see the companies are thinking about it. And, so we'll all learn what it is they're supposed to be thinking about it along the way. But I think that goes a long way.
Hey, Rebecca?
Yeah.
I got another question for
Yeah.
you. Going back to the clawback stuff, so the 304 has been around for a long time, and I think it's mandatory. The new clawback policy, can you just talk a little bit about what's mandatory versus where the board has discretion and this expansion to officers? I mean, you read the rule and you're sympathetic. You're like, okay, well, listen, if they screwed up their financials and people got paid as a result, then take the money back.
Right.
But, financial statements are incredibly complicated and mistakes get made all the time. I mean, look at PCAOB's budget, $700 million to audit auditors, right? Like, this stuff is incredibly complicated. So where does intent or scienter fit into the new clawback rules?
To the clawbacks, I would say it does not. So whether or not an individual executive is charged with, causing violations or actual violations themselves, that is very scienter based. The clawback, as far as I can tell from the reading of the rule and then how cases have been brought, now we haven't had cases under this new final clawback rules, but under, for example, the SOX 304 rules, we have plenty, and scienter is clearly not part of it. And even here under the new Section 10D rule, it does not imply that any of this is discretionary. It says mandatory clawback. And so I think a lot of what companies are looking at right now, what I would recommend to clients to look at right now is, have you considered that? Who do you consider to be someone with policy-making authority over, financials? Who should you be thinking could be subject to this? Do you need something in an employment agreement that mentions now that, this could apply to you, and even if you leave the company, we can still seek the mandatory clawback from you? You can't be indemnified for it. You might have people who retire and leave the country. How can you get, their compensation back?
Well,
Again, more
of
questions than answers.
Yeah, one of the things I'm thinking about is you can have a misstatement or a restatement of your financial statements that has no material impact on how the company is performing. But the statute says if you received compensation tied to a metric that was misstated, it's coming back.
Yep.
But what if the restatement was immaterial? I mean, what if it didn't matter? What if in the real world, the company was doing fine and its reports were good and blah, blah, blah? I mean, that just seems a little ham-handed. I mean,
there are many who agree with you. I think it's, as with everything, there's the rule and there's how it ends up getting applied and used. And I think there will end up having to be some gray there because, like you said, there's just times where it just flatly doesn't make sense. And, seems like it could trigger its own employee-based lawsuit on its own, which obviously the SEC doesn't have to care about, but, causes additional wrinkles. I'll also note that the new rule requires now companies to file their clawback policy as an exhibit to their 10K. So you will start getting examples of how companies are starting to deal with this. But I think, again, the idea is to kick off that discussion, get all of that out there, just like, you have to file your insider trading policies, now must be filed with your 10K. And I think you're going to start seeing at least more of a marketplace of ideas and examples of how companies are doing it. But as far as the actual enforcement of this rule, I mean, it's going to be interesting to see. I would assume the most egregious examples kind of get caught first, but I don't know.
the reason I'm asking is because some people early adopted. I mean, the proposed rules on clawbacks, they were proposed 10 years ago.
Yep.
And so then ISS and Glass Lewis beats on everyone and said, well, why you should voluntarily do this. Well, many of them did, but almost all of them provided for some discretion because they knew that sometimes you could have an accounting mistake that didn't really mean anything. Anyway.
Yeah. All I can do is nod and see what happens. But yes, no, I agree. It's an interesting question, and it's one that generate a lot of thought, but we don't know, practically speaking, kind of how companies and then how the commission are going to really enforce and enact this. Let's see. I think I have one Okay, I'll address that one later. All right, we're kind of at the very end. Any last questions? We have like 2 minutes. I will also note that there's an interesting report the SEC has to put out their annual whistleblower report every year, which talks about how many whistleblower complaints they got, how many tips, how many cases they brought, and how much money was awarded. That and the SEC's Division of Enforcement congressional, I don't know what they actually call it, report, I guess. Those are both public documents and can be really, interesting reads on what they're focusing on. It's where you get all the stats and numbers and things that you see in presentations, but they'll break down, how many individuals were charged or why, or how much a certain rule was enforced versus previous years. And, they can be really good signals and recaps into the previous year that kind of go beyond the kind of fun headline cases and dig into, like, we were actually enforcing this one rule that generally, I mean, when I was at the commission, which was only a year ago, that I left, it was mostly 10B, 17A, and reporting violations. And you're seeing more now, some of those technical violations that come as part of that. Whereas before, it was like, well, if you're charging them for fraud, you don't need to charge them for books and records. Like, they committed fraud, that kind of covers it. And now it seems to be more of a view that, well, if they committed fraud, they probably also broke these ones. And if they did, that needs to be included in the charging. And that's just something that varies based on division director and, chairman or chairwoman over the years. But thank you so much for coming. Let me know if you have any questions or things you want to see next time, and have a great rest of your week. Thanks, everyone.